I think we can start the session.
Done. Anytime you like. I'm all yours for an hour.
Right. So we are starting this session. So webinar on decoding judgments. A special welcome to the first year law students. Congratulations on starting this exciting journey in law school. So, as you step into this new chapter of your life, we are here to support you, to guide you throughout the complexities and throughout the challenges which you will be facing ahead. So, I'm very happy to be your host for this session today, and I really hope that you will find this session informative. So, the purpose of this series is basically to equip you all with all the valuable insights as well as the practical skills that will aid you in your studies and your future career. So, this particular session, it will help you to navigate the intricacies of legal judgments. Basically, you will learn how to read a judgment, how to analyze the same, what are the basics of judgments. So, since you are the first year law students, you won't be knowing much, but we will start from the basics. So today we are honored to have Ms. Shreya Meni with us. So Shreya is an advocate on record at the Supreme Court of India. She specializes in cross-border dispute resolution, commercial and criminal litigation. So she's also a gold medalist from Gujarat National Law University, and she has a very impressive track record, including her work with Shardul Amarchand Mangaldas and Suresh Ashroff. She has also won the Oxford Global Justice Award for Public International Law. Her contributions to the field and her experience is as a visiting faculty member at National Law University Delhi makes her an exceptional speaker for today's session. So let's make the most of this opportunity and just learn from her. So thank you all for joining, and I think we are good to go. We can start this session. Shreya, over to you. I
Thank you
think you're
so
on
much.
mute, right?
No, I'm good, I think. Now, can you hear me?
Yes, yes, we can.
Okay, great. Fantastic. Thank you so much for that introduction. I think the word that I caught from that introduction was exciting journey. So I'm very happy that in hindsight, after spending 11 years in the profession, I feel someone's at least referring to the journey as extremely exciting to begin with. So welcome everybody. I think Samiksha has put together this wonderful webinar for all of us in collaboration. Of course, we're doing this with the chambers and Manupatra, and I think it's an extremely helpful exercise that we're unveiling today, because I think this is one of the most important preliminary exercises that need to be done. Okay. So this is one of the first things you need to learn. Put your videos off, everybody. It would be just easier for us. So this is the first exercise we need to learn whenever we go to law schools. The first thing you'd be asked to probably discuss, talk about is judgment writing and judgment reading, because it is so basic. The first reliance that is placed in a court of law is on precedents. What are precedents? Past judgments, past orders. So if I can just request Darshana to put her video off. Samiksha, can you take care of that? So this would be the first reliance we place when it comes to looking at a judgment which is run or governed by the law of precedents. So every time we're referring to a precedent, we're essentially referring to a prior case law, a prior judgment, a prior order, which is binding now or to some extent persuasive. So two ways of looking at a judgment before I teach you how to read a judgment. Just get your pens and papers ready, because I'm going to be drilling you with information. Your first year, extremely bubbly and excited to be on this journey, but it's a hell lot of a roller coaster. Okay. So it's extremely, extremely tough, but very, very exciting and thrilling, like she said. Okay. So once you get the groove of it, which is going to be a few number of years, it becomes very, very thrilling. So, but for that, you need to know a method out of the madness. It can't be a headless chase of chickens. Okay. It has to follow a certain structure. There has to be certain structure of how to read a judgment. So that's exactly what I'm going to teach you and run you with information today. Pens and papers ready. So I'm going to run through 10 pointers essentially today. My first pointer is, when I look at this kind of a judgment or anything, is law of precedence. Precedents. Precedents. So a prior judgment, a past order, A similarly placed prior judgment or a past order would almost inevitably be required by the court whenever they are looking at your case law. So the most important thing in a judgment is looking for similar case laws. So the entire judgment, a sample that we've culled out today, Samiksha and I've culled out one judgment for us to analyze how to read. So we're going to look at that judgment and see how many number of prior case laws are referred to. Because judicial discipline, judicial hierarchy governs which court is above whom. So suppose for on the criminal side, we have a court of Metropolitan Magistrate, Sessions, High Court, Supreme Court. On the civil side, we have a civil judge, a district judge, a High Court, a Supreme Court. So this is our judicial hierarchy. This is called the hierarchy. So every time there's a past order, the higher court is going to bind the lower court's order. So if you have a Supreme Court order and you're fighting a case law in the High Court of Delhi, the Honorable Delhi High Court, and you show a Supreme Court case law exactly on the point, your judgment is going to be rendered in your favor. So the easiest way when we read a judgment is keep the law of precedence in mind. So you'll exactly know which judgment is binding and which judgment is at best persuasive. Okay, I hope everyone's clear till here. Obviously, judgments which are given by courts higher in the hierarchy are going to be binding. Judgments which are given by coordinate benches or below are going to be persuasive. So Delhi High Court single judge and Bombay High Court single judge, same stature, same level, coordinate benches. So any judgment given by the Delhi High Court can never bind the Bombay High Court. It can only persuade at best the Bombay High Court. But if it's a Supreme Court judgment, it'll immediately bind the Delhi High Court. So whenever you're researching a past judgment, you must always keep care what is the forum, which is the court of law, whose judgment you're taking out. Okay, that clarity has to be there. And then you will know whether it will be persuasive or binding for your court, which is, of course, what you're going to determine by judicial hierarchy and the law of precedence. Okay. You're going to do this much in detail, but today's session with Manupatra essentially deals with how to read judgments, because I think this is an excellent platform which I started with. So when I was in law school, we didn't have any of these SCCs which were so popular. So for us, it was Manupatra actually. And there was no India Kanun also at that point in time. So Manupatra was the first portal that I also started with. It was an extremely helpful portal. And I think she's going to give you some features which is going to make life much easier for you. So let's start reading the judgment, and I'll keep on telling you what to keep in mind when you're reading the judgment. So Samiksha, if you can just quickly share the screen. I want to see the first page, please.
Right. Doing it in a second.
Yeah. So every time for every case law, right on top, you'll have the court's name. Okay. The court's name. And above that, you'll have a citation. Citation. Ye likh lo. Citation. Citation. Today's session is very useful for life for you, okay? You're going to follow this not only through the anvil of your 5 years when it comes to law school, or 3 years, depending on which course you're in, but also for the fact that you're going to almost use this throughout your research career when you become a lawyer, okay? So I'm pushing in this information right at first blush with you. As first years, play with the Manupatra platform. You must know how to use it, and you must know how to play with it. So for that, you need to know what do you exactly need to look at. Don't read a 400-page judgment. You have to breeze through the judgment, and I'll teach you how. So if you see the screen, right on top is a Manu citation, okay? This is specific to Manupatra. So this is your equivalency to any sort of neutral citations from other law journals. Other law journals like AIR, SCR, Scale. So if you can just zoom in a bit, Samiksha, the top portion where the Manu citation and the equivalent citations are there. So if you all look carefully, the thing we need to focus on is the Manu citation. So that's your citation specific to Manupatra. Below that is an equivalent citation. Okay. So for SCR, AIR, All India Reporter, Scale. So in the Advocates on Record exam, for instance, we get SCR journals. So your catch has to be very specific that you have the corresponding Manupatra citation to avail its features. Okay, so that's one thing you need to remember. Then you have the court name. So my second point today, first was law of precedence with judicial hierarchy. My second point today is court name and citation. This is very important. So whenever you need read any judgment, what you need to figure out is citation, Citation is the details, the log journal details that you're going to get, with respect to which, like a physical hard copy journal, we're able to take out this page and this index and this volume number. Exactly like that, Manupatra gives you an electronic citation. So that's your e-citation. So this is extremely useful. And this is recognized in court as a valid print. Okay, so you can take this to a high court or a Supreme Court. You don't have to look, so you can't take an India Kanun printout. Okay, they're going to make a mockery out of you. Don't do that. So you need something so specific, which is a validated journal print to say that this is good law. So you can't take a simple print and go like that from an India Kanun free portal. You can't do that. You'll have to look at one of these hard copy journals or an electronic journal like Manupatra. Okay. Now what you're going to do is you're going to look at the court, because the court is going to tell you how far this judgment is binding on you. Okay, very important. Now if we go down, below the court name, Supreme Court of India is in bold. Right below the name of the court is what gives you the jurisdictional mold. So it says writ petition civil. If you can just zoom into that, writ petition civil. So we can file different kinds of petition in the Supreme Court. We can file different kinds of petition in the High Court, everybody. We can file different kinds of petitions in the lower courts, the trial courts rather, I should say. So you can file a bail application, you can file a writ appeal, you can file a special leave petition, you can file an original suit. So different jurisdictional modes. As you study consti law and the procedural laws throughout the anvil of your law school, they'll teach you different kinds of jurisdiction. Jurisdiction is the power, the authority of a court to entertain a matter. The power. Court ki kitni power hai ki wo ye matter sun le. Okay, that's the power of the court. So the power is again important to decipher judicial hierarchy, because law of precedence will be used to read the judgment and apply the good law. So all of this has to be kept in mind constantly. It's like a 360-degree view that you have to have. So you have to keep all of this in mind. Okay, so second point, very important, the name of the court, the citation, and the corresponding jurisdictional mold. So this is, for instance, what we've culled out today. Samiksha culled out this judgment because I requested that this is one of my favorites because it's the toughest. So today we're actually taking the toughest reading. So if you can read this one with me, you'll probably find it excruciatingly easy to read any other order or judgment on the Supreme Court or the High Court orders. Okay. So this is a writ petition civil. So you exactly know that the jurisdictional mold is a writ mold. And it says under Article 32 of the Indian Constitution, if you just read next to the highlighted portion. So it's also giving you the corresponding article. So the easiest thing is go to the Constitution and just open it. So for instance, this is a little pocket book, which I usually keep with me. It's a little pocket book of the Constitution. A lot of companies have this rolled out in the market. It's a very good idea to just catch hold of one so that you know what is the jurisdictional mold. And with the new laws, for instance, BNSS, new CRPC, and CPC, get hold of these 3 booklets for your jurisdictional mold. So all your first years, 3 booklets to read a judgment. Before you read a judgment, 3 booklets. One must be a little pocket book mini constitution. One must be, say, the BNSS Act, which you can find it on Google. You don't have to do anything. It's free. Just Google it. So have these PDFs downloaded with you so that you can instantly go and get to CPC, Civil Procedure Code. You can get to Bharatiya Nagarik Suraksha Sanhita 2023, which is BNSS, the new CRPC, and the last but not the least, the Constitution. So you can either get a mini book or you can just download the PDFs. That should work just fine. Okay. Now, next, the third pointer. Decided on. Now, this is really crucial. Right on the screen, it gives you a date. This is very, very important because the date will tell you how relevant is your judgment to read. Has the judgment been passed after, say, another judgment on a similar point? Last view is going to be binding, even though the bench strength may be lesser. So remember, if 5 judges, if there's a constitution bench of 5 judges who've held something about an arbitral award, the validity of non-binding nature of an award when it comes to non-signatories in an arbitral award, one example. Okay, or something about bails in PMLA, that, okay, someone who's involved in the liquor scam cannot get probably bail because it's PMLA, Prevention of Money Laundering Act, it's reverse burden of proof, no bail, statutory bar. But after that, 2 judges have held something different on a later date. Then that 2-judge bench, even though it's smaller in strength, It's going to bind the 5-judge bench because it's much later in date. Of course, we are going to see the nitty-gritties of the application. I'm just giving you a general view. So this is also called doctrine of merger. You can just quickly note it down. Doctrine of merger. So the later dates order will merge, subsume. Big fish eats the small fish. So later dates order is the big fish. It'll eat up the small fish, which is the previous dates order. So decided on. So you must, whenever you're reading judgments, always make a note like this is a 2017 judgment. So if anything is said by the Supreme Court about polygamy or nikah halala, this is triple talaq judgment today that we're referring to. Shaira Banu. So if anything is said in a nikah halala or a polygamy case subsequently, applying similar principles, say in a 2024 admission or a 2023 case, then is that going to be binding or 2017? So that is going to hold larger view depending on the wordings of that judgment. Maybe that judgment doesn't cover all the policy matters here. So we'll have to see the wordings, the nature, the etymology, the usage, the backdrop, all of these things, and then decipher how far doctrine of merger applies. To what extent will the big fish eat up the small fish, if any? Okay. So this is a generic rule. Of course, we can do one more session on doctrine of mergers or something if we find time, but that's a completely different prism. Okay. But just keep the date importance in mind as of now. Just as first year, this is the most important thing. Very, very crucial. Okay. That's going to determine how far this judgment is going to be applicable and to what extent. Next. Very quickly, now the easier part comes. So you can see there's the title of the judgment, appellants. So they're appellants. They've gone and writ appeal to the Supreme Court. Shaira Bano versus respondent. There's an and others. So there are multiple appellants. And then and others. So there are multiple respondents. Union of India, state, and others. So you could have the All India Muslim Personal Board who is protesting against the policy of the state interfering into the public health, morality, whatever. Everyone can have a different cause. So in REM matters, you can have lot of petitioners because it's against the general state policy or state view. But in personam matters, it's going to be limited. Okay. So two technical legal terms, check in a judgment. Is it an in rem matter or in personam? Public interest litigation would be in rem. Everyone's affected by it, right? The world will be affected. If tomorrow talaq is struck down, everyone gets affected by it in the country, right? So this is an in rem matter. But if I have a property, you're troubling my suit property premises, I go seek an injunction. It's an in personam matter. So we have two parties. So keep care about the parties because that will determine how far the judgment will apply and to whom. It's going to bind whom. So whenever you're reading a judgment, check. Is it against in personam or is it in rem? Okay, there could be a dilution. It could start in personam, assume in rem. For instance, what's happening with the RG Car murder case in Kolkata, the hospital rape and murder case, it started in personam. It was two parents who were actually troubled by their daughter's rape and subsequent death. But now this issue has assumed an in rem analysis. A suo motu cognizance has been taken by the Supreme Court. It's passing orders, it's passing guidelines, it's passing directives. Everything has changed from in personam to rem. So we may have certain more guidelines for safety at workplace tomorrow, which could bind everybody in the country. Okay, let's scroll down now. So this first page is the most important. So we're spending maximum amount of time here. This will give you the maximum number of leads to apply your judgment later. Okay, let's just scroll down a bit. Councils. This is easy. You will have councils from different sides named in the title. That's fine. Just scroll down, Samiksha, please. So you have different councils for appellants and different councils for respondents. So they are liberal. They sort of include everyone's name, whoever's. Okay, yes, stop. So point number three in today's session, case note. So I think this is the best thing Manupatra has done for us. It gives us brilliant case notes. I till date, and I can say this blindly across the bar literally, I rely on these case notes. So if I'm looking for something, if I'm searching electronically on the platform and I've found a judgment, the first thing I do is I don't even do a control F. I go to case notes. This is right at the second page or the bottom of your judgment. And this will give you what kind of laws are there in this judgment applicable. Suppose you're looking for any judgment brief on section 9 of CPC. So your case note will hit it out of the box and say section 9 CPC. That's it, as simple. Secondly, case note will tell you exactly what the judgment says in 2 lines, which is very useful. It'll raise also the question of law, which you're searching for palpably. So this is actually a beautiful way of even learning an AOR, advocate on record practice for the Supreme Court, because it not only gives you the question of law, but it's also going to tell you what's going to be the palpable answer for it. So it's going to give you substantive law. It's going to raise a procedural question of law and answer it for you on the subject matter. So let's read this one, for instance, family law, divorce laws. It's talaq, 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 so triple talaq, and the validity thereof. As simple. Is giving triple talaq valid? So I can formulate my case note. One line I've read and I know what the judgment is about. Section 2 of the Muslim law, so and so, so and so, so and so, Shariat Application Act. Fine, fair enough. Article so and so, so and so, so and so violated or not for assailing divorce pronounced by husband. So this is basically challenging someone's request wherein divorce has been pronounced by the husband. He has said talak, talak, talak to some Islamic lady in the country, and that lady, Shaira Bano, has gone up to the Supreme Court filing a writ petition saying this is an invalid practice in India. As simple as that. And now Supreme Court takes a view, is this talak, talak, talak void ab initio? What does void ab initio means? Jad se, root se, since inception. Is it wrong? So this is wrong since inception? Or triple talaq, can it be interfered with on the judicial side? Because it's a religious practice. It's a custom. It's a usage. It's a personal law. Like we have personal laws of polygamy. We permit a Muslim man to have multiple wives because that's what's permissible. So can a judicial court interfere into the personal laws? This is a constitutional law interpretation question. Void is from the beginning, from the inception. Ever since triple talaq as a practice was formulated, is it bad? If something is void since beginning, जिसकी शुरुआत ही गलत है, वो हमेशा गलत रहेगा. Okay, right? Next, let's just scroll down. So this is extremely useful. It gives you everything in brief, a bird eye view of the entire judgment. Facts. Case notes also give you facts. You can just read it later. It's very simple. Just scroll down, Samiksha. Very simple. It gives you the example of how Shaira Bano has come here. Simple. Now, the court in its case note also says whether, just 1 minute, now held. So the case note also gives you the ratio decidendi, the final judgment. So the case note is very crucial, point number 3, because it also gives you the ratio decidendi. You can note this down, ratio, R-A-T-I-O. It's a Latin word, ratio decidendi, D-E-S-C-E-N-D-I. Ratio decidendi. These are legally binding portions of the judgment. These are portions which legally bind what's going to come. This is doctrine of merger. Big fish eating the small fish entirely. These portions are going to prevail. So this is where there's the rationale of the decision. Why is this court decision binding legally? Why should it be considered a good precedent to be followed by the courts in future? So this is called a ratio decidendi. Ratio decidendi का opposite है obiter dictum. लिख लो. Ratio decidendi का opposite, right opposite, bang opposite is obiter dictum. O-B-I-T-E-R-D-I-C-T-U-M. Obiter dictum. Exactly the opposite of ratio decidendi. What's not binding? What's said in passing by the court? Anything which is said in passing is persuasive. It's not binding. Even on the Supreme Court, it's only persuasive. It doesn't possess a binding authority. It's a legal opinion said in passing. For instance, the judge says triple talaq is also banned in multiple countries, even outside India. This is a passing observation. It's not a ratio decidendi of the court. Ratio decidendi of the court is talaq, talaq, talaq is void ab initio. It strikes at the root of the matter. Fundamental rights can be violated. This is patriarchal. We need to promote gender equality. That's what the court's binding nature is when it comes to the talaq, talaq, talaq judgment. Okay? And doctrine of merger must keep in mind. So 3 points done. Yes. Now look at the screen. It says Justice CJI then rather, J.S. Kehar, comma, and Abdul Nazir, S. Abdul Nazir Justice, Honorable Justice S. Abdul Nazir, dissenting view. So there's a dissent. So in most of the Supreme Court and the High Court judgments, because you have more than one judge, you can have a dissenting view, which means an opposing view. I can hold, me and Samiksha are sitting on a bench. I can hold otherwise, she can hold otherwise. So we have a dissenting view. Or it could be a concurring view. We both concur with each other. We agree with each other. But we could have a different reasoning. That's also possible. We can both agree that talaq is bad. But I'm going to say it strikes at fundamental rights, hence it's bad in law. You're going to say it's bad because today we are in a domain where we must promote personal laws, but we can't do this because we can't interfere in personal laws. Judiciary can't interpret faith. We can't interpret the Quran. It's not right. So how can we say this is a bad practice? It's allowed also. Polygamy is also allowed. It's allowed by the Quran and we can't interpret Quran. But I know that even the Quran did not interpret this as such. Some sort of a Muslim law interpretation I make, and I come from that school of law, that it's not going to be hitting personal laws to the extent of fundamental right violation because I can't interpret a personal law. I'm a court of law. I can't interpret the Quran. But I come out with an analysis to now concur with this view by some other method. For instance, public order, morality. That to what extent do these customs and usages hit public order, which is also a fundamental right, Article 25. So competing fundamental rights. Article 14 कहता है सबको equality दो. Right to religion, freedom of religion कहता है जो religion कहेगा वो religion कर सकता है. Article 19. So Article 14 कहता है nothing doing. सबको equal rights दो. तो women के rights तो compromise हो गए इस religion के 19 के rights देने से. तो 19 प्रिवेल करेगा या 14, क्योंकि तलाक 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 तो 19 में फ्रीडम ऑफ रिलीजन और रिलीजन अलाउ कर रहा है ट्रिपल तलाक, ऐसा समझने में आ रहा है. But Article 14 is also there. Article 14 says women and man is equal protection of law. So is Article 14 going to trump 19, right to equality over right to religion, freedom of religion, or freedom of religion over equality? This is why this question came up. So this is how you have to read the judgment. Case note will give you more than enough. Yes, let's proceed, Samiksha now. Simple. Now the simple part comes. We've done the tougher one, okay? Now the simple one. Let's just scroll down, please. Let's scroll down. So Kurian Joseph, Justice Kurian Joseph. So they both give a dissent. They don't agree with each other up above. And then there are concurring views. Rohinton, Nariman, Yu Lalit. So you can see different judges giving different views. Just 1 minute. So the majority opinion is given by Justice Kehar and he puts out an index. So in most of the bigger cases, okay, just scroll down a bit. In most of the bigger cases, that means questions of law, larger questions of law, for instance, you will have an index. This is an index. So which page has what is indexed here? Okay, right. Just scroll down the index. Now the judgment starts. So my fourth point is you must have an index. Okay, you must know how to read an index because an index is simple. It is just segregating what's written in the judgment. Now comes the judgment. Now point number 5. The first para of the judgment will give you the cause of action. Note it down, please. Very crucial. Who has come to court and why have they come to court? So the first para of a judgment, a good judgment, first para, usually 99%, gives you a cause of action. Let's read. The petitioner Shaira Bano has approached this court for assailing, challenging the divorce pronounced by her husband Rizwan Ahmed on so and so, wherein he affirmed in the presence of 2 witnesses that I gave talaq, 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 and hence like this I divorced from you. Okay? So this is the reason why Shaira Bano has come to court. This is a cause of action. And the prayer as well. So a good judgment will give you 2 things. It'll give you a cause of action and it will also give you a prayer clause. See the highlighted portion at the bottom. The petitioner has sought a declaration that the talaq-e-biddat pronounced by her husband be declared as void ab initio. So that's a prayer clause also. So the easiest way is, and what is he saying? He's saying it's not valid because it's not part of the Shariat Muslim personal law. Just scroll down. And it's violative of the, please scroll down. Samiksha, just scroll down the screen. It's violative of the sacrosanct tenets of the Muslim religion and violative of Articles 14, 15, 21, etc. of the Indian Constitution. So the first para gives you everything. It gives you a cause of action, why the appellants have come, why have they approached this court, on what pretext, who are they, and what are they seeking. She's seeking a declaration to strike down this particular triple talaq directive, this practice, which is being propagated by Islamic law. Okay, great. Para 2 tells you that there are counters affidavit which have been filed. So there is an entire petition, writ petition, and then there is counter. Scroll down, Samiksha. So it basically tells you what's been filed. Okay. So that's your fifth point. Always remember, after the index, fourth point, your fifth point, which is basically first para, very crucial. If there's a lower court order you're challenging, that will be the impugned order. Just note it down. Impugned order. IMPUG. G is silent. NED. Impugned order. Yes, I'm repeating. Impugned order. Now, this is a writ. Otherwise, if it's a bail, for instance, High Court has rejected your bail, Sessions Court has rejected your bail, now you've come to Supreme Court. Like, for instance, Mr. Kejriwal comes to Supreme Court. So whenever you come to a higher court, you could be in a challenge against a High Court order. So High Court order dismissed. Now you're coming to Supreme Court for relief. So in that, in the first para, you'll also have reference to impugned order. Impugned order is the order under challenge of the High Court or the trial courts. The order under challenge is the impugned order. The order you're assailing, the order you're impugning, the order you're challenging. So that is also referred to in the first para. So fifth point, first para of any judgment is crucial, gives you cause of action, why you're coming to court, what you're seeking, your prayers, and impugned order reference, if any. Is everyone clear till here? Okay, good. I'm proceeding further. Okay, next, Samiksha, can you just please scroll down quickly? So this is extremely helpful for our understanding on the platform, okay? You have to keep all of this in mind when you're reading a judgment. First para, very, very important. Okay, yes, one second. Wherever you see a highlighted portion, just stop for a moment. It is the case of the respondent. So next, a judgment describes, next point, point number 6, a judgment describes the case from both sides. So whenever you're reading a judgment, so suppose you may have a judgment which is against you. It doesn't follow to what you're looking. Suppose I'm looking at, say, for instance, a research proposition on, say, grant of bail in anti-corruption matters. Now, this is a case where bail has not been granted. But I'll find the arguments. What has been argued by the petitioner's counsel? Why should he come out of jail? What is the defense he has taken? So I can find similar defenses and then I can take my own defense. So I'm trying to teach you that this is very important. Whenever the judge is considering the rival contentions of the parties, then it's very crucial because that will help you look for arguments. So point number 6, the easiest way to build arguments is look for a judgment and read what is the case of the petitioner or the appellant and the respondent. So for all you first years, there's nothing new in law. It's all cut, copy, paste. Whenever my chambers work, whenever I work, whenever we have interns in the office, this is what I tell them. That the easiest way to make a petition is look for a judgment where this point of law has been discussed. Get on the Manupatra website. Just look on the search platform for this particular subject case law. You'll find a sample judgment. Look at the first para. It'll tell you, and the case note. It'll pretty much, the head note will tell you everything. Then just see, do a control F for either it is the case of the petitioner or respondent or it is the rival contentions of the parties, or the parties have argued that. You'll find pretty much the defenses from both sides. Okay. Then you read whatever each of the lawyers have said for each of the sides or each of the parties. That's your point number 6. That's how you build arguments. Okay. Let's scroll down. You don't need to waste time too much on this because your head note has pretty much summed up what's coming. Okay. Samiksha, just scroll down quickly. Wherever you see a bold portion, just stop. Yes. So now he says, based on the above, the case of the respondent is that he had pronounced talaq in consonance with the prevalent valid mode of dissolution of divorce. So all in all, husband has argued that, look, I am a Muslim man. I am governed by Shariat law, Quran, and these permit me to give talaq-e-biddat, which is basically talaq, talaq, talaq. I am permitted in law, in Muslim law, which is my personal law, which I am governed by. Despite living in India, I still have that halo of my personal law. We don't have UCC still. That's why we are reading this judgment. So this is very useful for you today's session. because we are now having discussions about UCC, right? So let's see how this is going to come into play, because UCC has still not come into effect. We've notified it, but we still haven't applied it. State-wise application is being done. UP has applied it, for instance. So they are cutting FIRs. They're lodging FIRs there for triple talaq violation. Very interesting. Okay, let's go ahead. So read what both of the parties have said. Okay, that's your point number 6. So the judgment will clearly give it to you. Keeping in view the factual aspect, as also complicated questions for us arise, so we are going to adjudicate. Now part 2 is reference to that index. Part 2 says practice modes of talaq amongst Muslims. Now this is your obiter dictum. So this is where the court is analyzing what kind of talaqs are practiced in Muslim population in India. So this is in passing. The court is referring to the law in general. The court is talking about the law in general. So this you can skip. It's a generic discussion. You can read it if you're giving an advocate on record exam, or if there is something important, but obiter is usually not binding. So it's the part you need to not focus on too much. So Samiksha, if you can just quickly scroll ahead. I'm short on time, so I just want to get down to the ratio with them. So both sides will argue, and then the court will look at it from its own perspective and consider each and every argument in obiter which each side have raised. So if one side has said, look, oh, 1 second. So see the country names. So the petitioners, the appellants have argued that Morocco, Syria, Lebanon, if you can just keep on scrolling, Libya, all of these, Algeria, these are Muslim countries, Pakistan, Bangladesh, which have also condemned talaq, talaq, talaq. So this is what we're also arguing in India, that being Muslim countries, if they can conduct, see, United Arab Emirates, Dubai, if they can condemn a practice of talaq-e-biddat, why not us? We as a country should also condemn it. So this is our argument. Okay, one of the arguments, one of the limbs of the arguments. So this has been considered an obiter. Okay, go ahead, scroll. It is also contended by the Learned Senior Council that settled principles apply to all jurisdictions, including India. So the court is discussing the law. It's thinking aloud, essentially. Okay, none of this is binding. Jargon, obiter. Okay, it'll help you make arguments as a good lawyer, though, when you're preparing your memoranda, your briefs, your memos, whatever. It is submitted by Learned Counsel that it's essential to recognize the existence of distortions in hadith. So they are now analyzing the Quran and the hadiths, the personal laws. They're now seeing what portions of the Quran, what portion of the hadiths, what portions of the prophets' proclamations talk about talaq, talaq, talaq. Miss Indra Jaising, senior advocate, entered appearance as well. She studied. So I'm representing Miss Zakia Soman, who was also a petitioner here at the time of triple talaq in the polygamy petition. So we've filed another petition subsequent to this, which is pending. It's sub judice in the Supreme Court as I speak, so I can't talk too much about it. It's on abolition of nikah halala and polygamy. So there we've raised all these points which were adjudicated in triple talaq. Yes, Samiksha, scroll up. This is all obiter. This is all different lawyers putting out their views on what the court has asked, and this is what the court has thought about those views in passing. Okay, hold down. This is all what learned counsels from either sides have submitted. Simple, nothing too much to worry about. As long as you're clear on the head note, you should be fine. Okay, just scroll down. One more important thing which I have to tell you. One more important thing. Just keep scrolling till you find something emboldened. Please note it down. The 7th point today. It's very crucial to look for competing arguments. Okay, competing. What do I mean by this? अगर आर्टिकल 14 पे petitioner ने कुछ कहा है कि ट्रिपल तलाक violates आर्टिकल 14, right to equality, puts man and woman at a different footing, because man can say talak talak talak, but woman can't say talak talak talak. लेडी तलाक तलाक नहीं दे सकती है 3 बार बोल के, आदमी दे सकता है in Islamic law. So this is why this practice is discriminatory per se, prima facie. Whether it's allowed by Quran or hadith वो अलग बात है, लेकिन आदमी दे सकता है 3 बार तलाक बोल के तलाक की बिद्दत, लेडी नहीं दे सकती, वो खुला डिक्लेयर करेगी. This is a substantive law. I practice family law, so I know. You learn when you do family law. So all of this, look for competing arguments. If the petitioner or the lady is saying that talak, talak, talak is invalid because it's discriminatory, see how the husband answers. Husband says it may be discriminatory, but Quran allows it, and court cannot interpret Quran. It is my personal law. ठीक है, everyone's understood till here. दो rights की लड़ाई है, तभी कॉन्स्टिट्यूशन आ गया into play, तभी सुप्रीम कोर्ट जाना पड़ रहा है, वरना हाई कोर्ट चले जाते, वरना ट्रायल कोर्ट चले जाते. लेकिन दो कंपीटिंग फंडामेंटल राइट्स आ गए हैं, तो सुप्रीम कोर्ट जजमेंट रेंडर करेगी. जब सुप्रीम कोर्ट रेंडर करेगी तो उस जजमेंट को पढ़ने के लिए दोनों की कंटेंशंस पढ़ी जाएंगी. ओके, स्क्रॉल डाउन. Very simple. Let's go to the meatier part now. Now let's go to the real portion. So now I want you to come to, I'll just get you to the point 8 now. Now I want you to see. So this is simple. And then they will literally take each of the contentions in the, like for instance, if you come to page 233, if you come to page 233, Samiksha, you'll be able to see that I've just emboldened it on running page 233. I've emboldened that one line. So the court is analyzing everything, basically, what is being said. Yes. And finally, come to page 243, conclusions. So the 8th point is conclusions. This is that I was telling you, impact of international assessments and etc., agreements, etc. Okay. No, not every matter is connected with the constitution. I'll just explain in a minute. Okay, अब अगली चीज दो देखनी है, para number, so if you come to this, yes, see para 10 here, which is a para of the index that they have made in this judgment. Conclusions emerging out of the above consideration, for all of you who's new to the legal field, this is the ratio decidendi. These are our conclusions. Whether these are binding or not, yes. But in similar facts, in similar circumstances, and you can distinguish a judgment. So you have to read a judgment, because later, when you are perusing that judgment in court, you're placing that judgment in court, the other side is going to say, ये judgment apply नहीं करती हैं, ये different है, ये distinguishable है. तो तुम्हें judgment distinguish करने के लिए भी पढ़नी पड़ेगी और same बोलने के लिए भी पढ़नी पड़ेगी कि doctrine of merger apply हो गई. So point number 8, ratio decidendi is what is binding, which are the conclusions emerging out of the consideration. However, obiter is important, because even though it's not binding, what is said in passing, जो ऊपर हमने कहा जल्दी scroll कर लो, obiter dictum है, binding नहीं है, लेकिन जजमेंट आगे अप्लाई करेगी या नहीं किसी केस को. मान लो आप कोई केस लड़ने गए और आपने कोई जजमेंट निकाल के लाया पुरानी, अब वो जजमेंट अप्लाई करेगी या नहीं, उसके सेम फैक्ट्स होंगे तो अप्लाई कर जाएगी. सेम फैक्ट्स और सेम ऑबिटर होना चाहिए, सिमिलर, तो वो पढ़ने के लिए ऑबिटर पढ़ना पड़ेगा. आई होप दैट्स क्लियर टू एवरीवन. रेशियो इज बाइंडिंग, but a bare reading, a bold, quick reading of the obiter is necessary to know and gauge similarity of whether the judgment would be applicable in future or not. So you have to read the judgment like a breeze as far as the obiter is concerned, and dig deep and go very, very in-depth when it comes to ratio. Next, the following conclusions emerge from the considerations recorded above. Despite the decision, the issue needs a fresh examination. So the court has held 2, 3, 5 things that it would be sinful, because talaq-e-biddat is allowed by the Hanafi school. We can't interpret it. And of course, it is also probably affirmed by the hadiths. We don't know. They've given on merits. Substantive law. Just scroll down and come to part 10, the declaration. So they've given conclusions as to what they think in general in point 8. Okay, about what the judgment says. And then finally, there's a declaration in part 10. So the declaration is what the court is declaring. Now, the court says we have adopted an aggressive posture, the Union of India, seeking the invalidation that it violates fundamental rights, and by further asserting that it also violates morality. Scroll down. Scroll down. They say religion is a matter of faith, not logic. Please scroll down. Please scroll down. See, 193. Religion is a matter of faith, not logic. So the court says this is faith. We can't logically reason triple talaq like this. Go down, scroll down, para 195. And this is what the court says. The court says, look, stop. In continuation of the position expressed above, we acknowledge, I'm reading 195, we may acknowledge that most of the prayers made to this court were persuasive to solicit acceptance. They say we are persuaded. It's a bad practice. A man can say talaq, talaq, talaq. Woman can't say talaq, talaq. Either equate the practice. So prima facie, the practice appears wrong. Wearing of hijab, see, all of this may be controversial, and because I'm a woman, I may believe differently. You can have a different view. But prima facie, the court is saying, look, this has to be balanced at some level. But the court expresses one inability. It says, we are, however, satisfied that it would not be the rightful course to tread. We were obliged to keep reminding ourselves of the wisdom of, please scroll down, the wisdom of the framers of the Constitution, right on top, who placed the matters of faith in part 3. So they said, no doubt, equality is in part 3. Part 3 is fundamental rights of Constitution. Part 3, binding. That means right to equality is binding. So you can say talaq is bad because right to equality hai, और वो binding है fundamental right में. Writ लग सकती है Article 32 की. लेकिन जैसे fundamental right to equality binding है part 3 में, वैसे ही फ्रीडम ऑफ रिलीजन भी बाइंडिंग है, मोरालिटी एंड पब्लिक ऑर्डर फेथ भी बाइंडिंग है, वो भी पार्ट 3 में प्लेस्ड है. तो कोर्ट कह रही है, वी अग्री विद यू दैट इट्स प्राइमा फेशी वायोलेटिव, बट बिकॉज देयर इज राइट टू फ्रीडम ऑफ रिलीजन एंड वी कांट इंटरप्रेट रिलीजन, that is also a competing right. So the court takes an easier route and the court skips out. So point number 8, court says we are going to direct the state to look at this. If you just scroll down, right at the end, para 197, they exercise article 142. I'm not going too much into this. That's their inherent power. वो उन्होंने अयोध्या में भी यूज करी थी सेटल करने के लिए. और फाइनली वो कहते हैं, we are satisfied that this is a position where, yes, the court, instead of the court, the judges, instead of the judges, the state should look at it. Para 199, please. Scroll down. Last thing, guys, almost over, just 2 pointers, very small pointers after that. Yes, 199. In view of the 199, I'm quickly reading just to sum it up. In view of the position expressed, we are satisfied. This is a case where a situation should exercise to issue appropriate directions under 142. We therefore hereby direct, last line, the Union of India government to consider legislation appropriately, particularly with respect to talaq-e-biddat, talaq. We hope and expect that the legislation will also take into consideration Shariat law, as has been corrected by legislations world over. So even though Pakistan doesn't allow it, Morocco doesn't allow it, Syria doesn't allow it, we as courts, because we have distinct separation of powers, we are not going to frame a law striking down talaq-e-biddat. We direct the Union of India to frame a law. And in that time, we injunct para 200 till such time, scroll above please, till such time, para 200, as legislation in the matter is concerned, para 200 please, we are, Samiksha, can you show para 200 properly? We are satisfied in injuncting Muslim husbands from pronouncing talaq. So जब तक तलाक, ट्रिपल तलाक प्रोटेक्शन एक्ट नहीं आ गया, अब आ गया है, penal offense आ गया, एक छोटा सा एक्ट बना दिया उन्हें कि जो भी मुस्लिम मैन तलाक कहेगा इंडिया में, उसको जेल में डाल देंगे, ये नहीं हो सकता, तलाक-ए-बिद्दत बैन कर दिया है. तो उसके टाइम आने से पहले, because there was a gap in the law, they filled it by an injunctive directive and they disposed of. इतना एनालिसिस करने के बाद उन्होंने यहाँ छोड़ दिया. ठीक है, this was point number 8. Now point number 9 and 10, 2 more points and then I'll open the floor. Point number 9, just scroll down please. Point number 9, you'll see other judges' opinions. Okay, just scroll down please. You'll see emboldened opinion of another competing judge on the bench, Justice Korean Joseph. Scroll down please. It's emboldened. You'll see Justice Korean Joseph. I think you've gone up above. Page 249, dear. 249. So this is Justice Korean Joseph's opinion. Of course, it's another opinion. It's a concurring opinion. It's not a dissent. Okay. 249. Page 249. You'll see it. It's there. So you can have other judges' opinions also. That also manupatra tags for you right at the bottom. So that's your point number 9. Look for other judges' opinions and how they are distinguished from the majority view. So this is it. Justice Korean Joseph on your screen. So you have a majority view and you have a minority view. So your minority view can be a dissent, differing view, or a concurring opinion. Concur तो कर रहा हूँ, agree तो कर रहा हूँ कि तलाक bad है, लेकिन ये नहीं मानता कि state को देखना चाहिए. मैं सोचता हूँ court को strike down करना चाहिए. That's what the route Justice Korean Joseph very daringly takes. Okay, this was point number 9. And point number 10. Point number 10. Every judgment will have one X factor. This is my giveaway to you. There's a crux of the judgment. Judgment का एक crux मिलेगा कि judgment का एक summary जो आप draw करते हो, वो आपको crux खुद बनाना है. When you read a judgment, that's your takeaway. So my takeaway, for instance, my crux is triple talaq, 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 talaq challenged. However, the court says we can't interpret religion because there are two competing fundamental rights, equality and religion. But judges take different views. In the end, Union of India is left to decide. This is my crux of the judgment. So, how to read a judgment? You must always end with a crux in 5 lines for yourself. This is the fastest way to read a judgment. Yes, Samiksha. That was my giveaway. I think this is the easiest I could have sort of broken it down for you. And I hand over the baton to you. For the uploaded versions, you can check with Samiksha and Manupatra. But I think this is the easiest way to sort of look at a judgment when you sort of read it. Yes.
Thank you so much, Shreya. I think you have covered all the important parts, and they must have, gotten a gist that how to read a judgment, what are the important features, what to look, and all. Basically, you have covered everything. So now, what I'll do is I'll show that how to search for this judgment using Manupatra. I'll just share my screen once. We will be having the question and answer session towards the end. We can have a 5 to 7 minutes Q&A session. So I'll just share my screen and show the features on Manupatra. Right. So I hope my screen is visible. All right. So when we open the home page, so this will reflect like this. I'll show you. On the left hand side, we have the table of contents. And on the right hand sides, we have all these features. So what we'll do is we will click on Manu search. So since this was a triple talaq judgment, right? So what we have done is it's just a simple click. We have clicked on Manu search. We will write triple talaq and we will just search for it. So I'll quickly explain. Manu search is basically like a Google keyword search. When I click on it and when I search for the keyword, which is triple talaq, what I'll see is that the judgment, it will get reflected over here. So it's loading, right? So you can see that when I search for this, I have the judgment on my screen. When I click on this judgment, so the whole judgment will appear. The downloaded version of the judgment was just now showed to you all by Shreya. Now this is on the tool I'm explaining how to open it. So when I click on it, the judgment will open up. Right. So this is how it gets opened up in Manupatra. I click on all. So this is the first page which will get reflected. This is the Manu citation. This is the neutral citation. Since in quotes, now we also follow neutral citation. So we have that as well. We have the subject of it, constitution. We have the quorum. You can see, you can click on all these. Everything is just clickable and it will open. This is the case note, which was very beautifully explained. These are the all the cases that are referred in this case. This means that all the other cases which were similar to this, these were referred over here. Let's say I click on this case and you can see that it will get reflected. So while clicking on it, you can see that this case will open up. We also have all the acts, constitution, and all the articles which are there. You can also see the citing references, how many times this case is affirmed, discussed, dissented. You can see the counsel, you can see the references, and this is how the judgment will look. So now I'll quickly explain all the features of the judgments as well. So you can directly print it out from here. You can download from here. You can also email this judgment. If you are a subscriber, you can email. You can just click on this email. And the best feature over here is that you can also mail it to a person who is a non-subscriber, right? So we can also save this document. We can create a folder by any name and you can save it. It will get saved over here. Then we also have the option of cited in para. So this option will show you that in how many future cases is this case cited and the exact para number. When I click on the plus button, I can see that this, in the case of Gaurav Kumar versus Union of India, this case was future cited. And para number 93 is for is the most important para, because it in this para itself, this judgment is future cited. You can see all the list of cited most judgments which have been future cited. Every list it appears. You can also view the commentary from it. You also have the mark para. You can also look at the authority check. Basically, it is the timeline check, that when was this case, basically when it started, and what is the basically the timeline of the same. You can also see that this will appear like, basically these are the all the other judgments which are related to this. And we have also, we have put it down like this. So these are the cases in which this judgment is cited. You can see that this color represents that, right? And then we also have the order timeline. I just showed you. Then you can easily sticky you can make sticky notes. You can highlight this judgment. If I want to highlight any part, I can click on any color and I can just highlight it, right? So it gets very easy, and it will be saved in your document in which you are highlighting. It will not get saved in the whole, like only in your part it will get reflected, right? So we also have the option of uh, the facts, issues, law, the all the this case, it will be easily reflected. The facts, what are the issues, very briefly it will get showcased. So you can see that the court, the judge, the subject, the disposition, what are the basically facts, what is the summary. So you can see that we have a brief summary over here, and you can view from it. And you also have while clicking on this option, you also get to know, because this is a 300 plus page judgment, so you can get a gist of the judgment from here. And these are the icons. So if in case you forget any icon, you can just click on the icon tab, and you all can just have a look at it. So this is one way through which you can download the judgment. The another way for it, you can see that this is the neutral citation. So when I click on the citation, and when I click on the neutral citation, so I click Supreme Court, I click on the year 2017, right? And I click on the number 785. I'll see. So while clicking on this, so basically what I've done over here is that I have added the citation number. Like I have added the court name, I have added the year, I have added the number, the case number. So through this, I can see that the case will get reflected through searching it by way of citation, right? So this is also another option which we are having. So first we did Manu search, then we also did then we saw all the features of the judgment, and then we saw what are the how do we see the citation. So through citation it will get reflected. I think there's some network issue with this, but yes, when you add the citation, so it will just show like this. And you can also basically do the legal search. So in legal search, you can I'll just refresh it again. Yeah, just a second. Yeah. So when I click on the legal search, what I can do is that I can also search by the name of the appellant. So when I click on the when I add the name, like I write Shaira Mano, so I can see that the name, through the name of it, the case will get opened up. So I just don't have to do anything. I just have to look for uh, the case through the name. So you can see that I'll add the spelling of it. I'll add the spelling of the appellant or respondent, and then I can see that this case will get reflected through the appellant or the respondent name. Uh, it is just loading. It will show in a while. Right, you can see. So we have many ways. Either we can look for the name, or through the citation, or through the manu search, through the keyword search. So these are the ways in which we can download a judgment. There are many other features, and we can have another separate session for that as well. You can also see that, this has been cited in Manupatra for 331 plus times, right? So this also shows that this case has some standing, because it gets very easy to identify certain cases which are very important, because these are future cited, right? So these are all the important features which you can see in judgments. And as I said that, if you all will be willing, then we can have another detailed session on how to download the bare acts, how to go about the other features. We also have certain commentaries, so all those we can have it in a separate session. So I think we can have the Q&A session right now. All right. So I'll just, if you all have any questions, you can ask in the chat box. All right. I think, uh, no, Nitesh. So for Manupatra, you have to buy a subscription. It's some of the features, like, we have the weekly wrap kind of thing, the weekly magazine, that all is free. I'll show you how to see some free features. Just a second, I'll show the free features. Just 1 second. Right, so for the free features, I'll just sign out. I think it is till the time it is just signing out, we can see another doubts. All right. How can we work with Manupatra? Okay. I think that, you may ask questions which are related to the judgment series. Uh, can you kindly tell 8 9 points that were mentioned? How can you say something? Okay, I think people are just asking and answering the questions on their own in the chat box itself. So if there is any question that is, pertaining to how to, if you're having any doubts regarding the judgment series, how to read, or is there any another doubt regarding that, please ask that. Or if you want to, okay, so we have a question: difference between conclusion and declaration.
Okay. So this one's interesting actually because conclusion sums up what's been said. Okay. So you could have a long discussion and you could conclude with, say, three things like the crux I was telling you. You could conclude with 3 or 4 points saying, this is what we conclude as to what has been discussed. But declaration is where you give your recommendation or opinion because you're asking for a promulgation. You have asked, the prayer is to strike down by promulgating that Shariat is bad in law. Shariat Muslim Protection Act is void ab initio. So you are asking it to be declared null and void. So that declaration of whether it's null and void will be given in the declaration column. Conclusion is after you've discussed the obiter, what is your analysis of the obiter? Your concluding or your conclusion, sorry, is with those 3 4 pointers. So that's the essential difference.
All right, I think someone is asking that they are having one moot court and they want to know about freedom of speech and expression. Can you guide me? How do I do my research regarding
So
that?
the best thing is look for judgments and look for any sort of electronic portal. So you can look at Manupatra itself. That would be a very, very great idea. So precedence. So there is primary source of law and secondary source of law. So in a moot court, you must look for primary source of law. So your primary source of law is your bare act, your statute. So your statute or your bare act is the constitution. So Article 19 will give you freedom of speech in the Constitution Part 3. So first go to Constitution and read one of the commentaries on free speech. And an easier way today is, of course, if you don't want to go through a DD Basu, which is a treatise, say, on a freedom of speech, the easiest thing is look for case laws. So now whether you're looking at press journal, media journal, freedom of speech to that extent, whether you're looking at freedom of speech in terms of parliament, what kind of privileges are there, what kind of and parliamentary notices are given almost on a daily basis. All the actors are receiving these days because Parliament was in session. So all of those who had appeared there, from say a Jaya Bachchan to a Kangana Ranaut, everyone's been slapped with a notice. So very interesting domain to feature what you're looking for. Freedom of speech and opinion is a speech and expression is a very, very vast subject. Free speech, silence, peaceful protest, right of strike of lawyers, media interactions. Can lawyers interact with media and to what extent? How much of news can you give there? So all of these informations are all included in freedom of speech and expression. What can you write? Can you tweet something? Now that would amount to sedition or not under the new law. So freedom of speech is extremely wide as such. So I don't know what specifically your moot court relates to. If you want to seek help, feel free to WhatsApp me or call me. I'll definitely help. Via email, you can get in touch with Manupatra Samiksha itself. If there's anything we can help with, I'll surely.
Shreya, they are saying that if you could quickly just in one liner just name the pointers, the headings which
That's
you
an excellent suggestion. But
right.
I didn't write the pointers. While teaching, I
Okay,
made
okay.
those up. So I think an excellent exercise would be if anyone's taken down notes to quickly just
Right.
jot it
If
down on
you
the
could
chat tab
just
and we'll just go one by one. If anyone can just put it down quickly. So point number one
right.
was, my email ID you can share, Samiksha, if you want. If anyone needs any
Right.
help, I think that's fine.
Right. I'll share. Shreya, if you could tell them what is neutral citation, AIR
Okay,
citation they
that's
are
the
asking.
That's important, actually, yes. So neutral citations are a new method which has been devised by the courts to give a non-journal citation to every judgment. So this is actually Honorable CJI's endeavor. He says that, look, we should not have any journal-specific citation. So what he's done is, without having a journal specificity, he's come out with some neutral citations. And of course, AIR is on board because that's the mother India of all citations and law journals. So that's the one they cull out, but they have a non-journal based citation, which is the court's citation. Okay, so the courts have given a distinct number because we are making a national judicial data accountability grid. And with that, we are putting everything online. So even a bail application, say for release of a vehicle, a superdari vehicle, if there's a theft, your mobile's been stolen, and the police officer says, okay, we found the mobile and he's deposited the mobile in court. Now in your local court, you're going to get the release of that mobile. Even that application is going to be electronically put on board that National Judicial Data Accountability Grid. This is so that at the click of a mouse, we can view everything. Okay. Yes.
Perfect. I think I have also mentioned the email ID so that, in case of
No
any
problem.
further doubts, they can discuss it further. So, what are the two type of petition I think they're asking?
So petitions are actually plaints, okay? It's how the CPC defines a pleading. That's where the definition comes from. So the definition of a plaint or a pleading comes from the Civil Procedure Court. It is by way of a plaint that we institute a suit. We go to a court. So a petition is nothing but जो अर्जी बोलते हैं जिसको हम अर्जी हिंदी में जब हम कोर्ट में अर्जी लगाते हैं, it's actually that simple, nothing else. Okay, so on the criminal side, this is the same petition. So appeal is when you're going against already an order passed by a lower court or a trial court. That's when you go and appeal, or a revision. You'll read these. These are jurisdictional molds. Writ is for the purposes of fundamental right violation. Like for instance, your equality was violated, so you went directly into a writ to Supreme Court. So these are different jurisdictions. In your later years of college, you'll read about what to file and where to file and what petition to file. This is almost literally 3 hour discussion to teach jurisdiction. Okay. Yeah.
I think someone has just stated the 10 points. That is great. And I think
Great.
the last
We can
question they
move
are
on to
asking, yeah, they're asking of the internship. I think they're asking under you, how do they
Samiksha,
get?
do one thing. Yes,
Yeah.
do one thing. Just take down their names and just forward me the names of the CVs. We'll probably
All right.
take 2 or 3 because we have collaborated with you as Manupatra. We'll try to incorporate 2, 3 people.
All right. Perfect. If I could have just, you know, I don't want much emails, just two, three emails, one, few who are interested, you can just put that in the chat box.
Yes, this is, sorry, just one more thing. Someone just
Yeah.
asked, is this the same for all? Yes, this is pretty much the same for all judgments to be read. This is as basic as it gets and as tough and as it can properly get. And it's wonderful that Manupatra has done this for you because whichever intern I get in office, I assume this prior subject knowledge. And I think this has made me also softer in my mind now, because I think no one walks them through this in law school, you know. We almost assume that they know this, and we give them a research proposition and we want a research in 2 hours. So yeah, I think it's fantastic.
Absolutely. So I think this was a great, great session, and I hope that you all have learned a lot from it. And I am hoping to see you for tomorrow's session. So we have that session on internships. So for those of you who are, searching for internships and have questions related to that, I'll see you in tomorrow's session, and all your doubts related to internships will be. I hope that all of them will be clear. So, Shreya, I think it was wonderful to have you. And thank you so much for explaining everything so calmly. And I really hope that you have learned a lot from this session. Thank you so much.
Absolutely. Likewise, thank you for discovering me. And we look forward to also a great collaboration with you. I look forward to working with you. Okay. I'll take leave with permission now. Thank you so much. Lovely, lovely session convened, Samiksha. Thank you.
Thank you, Shreya. Thank you so much. Bye, everyone. Thank you so much for joining. And as I told you that tomorrow we are having another session on internship. So I'll see you there in that session. And please join on time. You all may join around 3:45 or 50. And hoping to see you soon. So please don't send more email IDs. It's just that, I've taken a few of them. Thank you so much. All right. You all may leave now.